Those in the legal fraternity say suspended sentences should be extended to traffic cases for justice to be served. It comes on the heels of the sentencing of Roy Clivey Tamasa. He was handed 240 hours community service. He pleaded guilty to causing the death of Dr. Very Jones-Leslie by careless driving back in 2017. Attorney Richard Barton joins me now to discuss this issue, and I have to say we did get a lot of viewer feedback on this case. Good evening,
Hi, Tammi, how are you?
Barton, thank you for being here with us. So let's get straight to it. A suspended sentence. For those who may not know what it is,
right.
Can you put in a nutshell?
Thank you for having me. Mr. Benton QC was always also involved in the matter, and he led me in the issue. A suspended sentence essentially is a regime that allows the court to effectively impose a sentence of custody but suspend it for a period. So technically you have been sentenced to serve time in prison, but a judge has the discretion to suspend that.
It was not used in this case. Can you comment on that?
Right. The reason for that is because the penal code specifically excludes the traffic law, certain offenses under the traffic law, and death by careless driving happens to be one of those offenses. Also death by dangerous driving. And I know it has generated some controversy. This has achieved the attention of the Court of Appeal and also the Grand Court, because that's not the position that's reflected in the United Kingdom. In fact, there is a concern that there may be an incompatibility issue, and you've seen that being topical as well.
Correct.
Because we would say that the court should have such a discretion. I mean, we all have near misses. The careless driving is in three categories, essentially. That which falls just below dangerous driving, and sort of momentary inattention, and everything else in between. So it really is very difficult not to have that mechanism where someone just inadvertently glances or has a glimpse off the road. It is not excusable, but in the UK, the position is clear that such a mechanism is in existence.
So what is the remedy for us then?
Well, we would have to legislate. We would have to legislate or put it before the courts to have a declaration of incompatibility, because it is not consistent with a right to fair trial. And that is not to trivialize a suspended sentence, because you have that hanging over your head, Tammi. Essentially, the court has said to you, and under the alternative sentencing law, this mechanism is afforded to persons who are deemed worthy of that sort of type of sentence, because you could go to prison at any particular period in that window.
So there needs to be an amount of discretion that's exercised here?
We would say so, yes.
All right, Mr. Barton, thank you for being here with us.
Thank you very much, Tammi. It's always a pleasure.
And explaining the issue so that our viewers can understand.
Thank you.